with the Board of Equalization meeting. It's green. It's still quiet though. All right, how about now? There we go. Okay, we are ready to get started with our Board of Equalization meeting. Commissioner Stakovich is unable to join us today, so I will be chairing. As such, we will suspend the rules so that I can second any motion so that we'll be able to proceed through our agenda. And I think we've got everybody online, everybody's here. And we typically don't start these ones with a prayer and a pledge, so we'll just jump right into our first agenda item. The first agenda item is to approve the minutes of the Board of Equalization meeting held on June 23rd, 2022.
So moved.
And I will second that motion. All in favor say aye.
Aye.
Aye. That passes unanimously. All right. Item number 2, adopt an order calling for a special meeting of the Board of Equalization of Utah County for November 21st, 2022 at 2 p.m.
So moved.
I'll second that motion. All in favor say aye.
Aye.
Aye. That passes unanimously. Item number 3, approve a notice of cancellation of a meeting of Board of Equalization for Utah County on November 17th, 2022 at 2 p.m.
So moved.
I'll second that motion. All in favor say aye.
Aye.
Aye. That passes unanimously. Item number 4, approve the Board of Equalization assessor-approved review process report. Report date of 8/24/2022.
So moved.
And I will second that motion. All in favor say aye.
Aye.
Aye. That passes unanimously as well. Move on to item number 5. Approve or deny assessor's office request to change taxable status from primary residential to secondary residential on the parcels on the attached list to the agenda for the tax year of 2022.
Okay, so this first one here, there's 2 of these properties. There's 3 on the list. 2 of them have been identified as short-term rentals,
Okay.
and they've established the personal property accounts that go with them. And then the other one is the taxpayer owns 2 homes. One of them they live in, and the other one that's adjacent, they just run their business out of, and they have indicated that nobody lives there, so it doesn't qualify.
Okay. Do you have any other questions?
Nope. No questions.
All right.
I'll make a motion that we approve item number 5 as stated on our agenda.
There are 24 properties on this report. These are parcels that we moved to secondary last month through the residential declaration, where they either didn't answer correctly or they didn't answer at all. And so we send them a notice, and they are now appealing that decision, and they've provided the proof to show that they qualify.
Okay. Do you have any questions, Commissioner?
So let me make sure. So the applications, you went through the whole process with them, and all the property owners are in agreement with what we're doing, or they have not responded.
These
No,
are the ones
these-
we're putting back on.
These we moved because they didn't respond to the residential declaration or the failure to file notices. Or they answered no when they didn't understand the question and it should have been yes, but they got moved to secondary on last month.
Oh,
We
okay,
moved
got it.
a
Okay,
big number
okay,
of
now
them.
I tie
And
it.
I expect we'll see a fair number of these every month for a while as we get through that backlog.
Yeah. Okay. Okay. Ready for a motion?
Mm-hmm.
So I'll make a motion then that we approve item number 6 on our agenda.
And I'll second that motion. All in favor say aye.
Aye.
Aye. That passes unanimously. All right, moving on to item number 7, approve or deny application for review of the Board of Equalization of Farmland Assessment Act status for Dew Bradley, Raymond, and Lisa Ann, serial number 0003, Greenbelt account number 583-2022. How are you doing?
Good. I'm Brad Dew. I had assignment from the prior 3 meetings, specifically the June meeting, to come back with my preferred option, because there are multiple options. My preferred option is to have the Board of Equalization deny my appeal, to work with Mr. Jones to be able to meet before the Board of County Commissioners for Green Folder 1347 to appeal there.
So will this be moving it to the Urban Farming Act? Is that what we're doing? Or what's the, which one are we doing there? Is that
Right.
Right.
I would give those.
Well, yeah, if I recall correctly, I think we had some uncertainty as to whether or not Mr. Dew's property would qualify for urban farming.
well, he has water shares. He would just need to utilize them, right?
So I've worked with the developer behind me, with Strawberry Water Association and Mapleton Irrigation Company. The developer behind me is in a multi-phase process, of which directly behind me is phase 6. They are non-committal on the timing that they'll complete their excavation, based on all of the dynamics of what's going on. And so I haven't been able to get a date from the developer of when we would be able to actually make a connection. In the meantime, I have started the process of irrigation just with the water that I have. I'm using city water and I'm irrigating. And it's a temporary solution, I certainly hope, because of the cost.
But you have a line of sight that get your irrigation water that you own to the property.
Correct.
At which time then he would qualify once we have that irrigation water on the property.
So, but I'm irrigating now.
Right.
So I would argue that I qualify today, even though it's far more expensive irrigation. That is not my desired long-term solution, but I started last month irrigating and will continue to irrigate as if I had access to strawberry water, which I will have. But my understanding is that the proper approach is to request a denial of my appeal to the Greenbelt, to go before the Board of County Commissioners requesting Green Folder 1347 to be able to then qualify for the agricultural tax on my property, which is really critical because the combination of the potential rollback tax and the increase that's been submitted to me for even 2022 tax is a really big number.
Yeah, I would agree. And I would personally, my personal opinion, not my legal opinion, is that I agree that your land qualifies for the urban greenbelt anyway. Just because you're not currently utilizing the irrigation water, you have irrigation shares for that piece of property. Therefore, it is irrigated property. Whether or not you're using those shares to water the property, you're still watering the property and you still own the shares. Just like if your ditch collapsed and you were watering with something else in the meantime, you still have irrigated property. I think that's a good path forward for you. And I think you'll be able to maintain the farming status.
And for all of 2022, we have qualified both in agricultural production and annual animal units.
Okay, so it was just basically just acreage that you didn't.
Pardon me?
It was just acreage that you didn't, right?
Correct.
Yeah. Okay.
Okay.
Keep working with that developer because you have a right of way for those water rights.
Right.
Good. Okay.
Very good. I'll make a motion then that we deny the application as presented to us in item number 7.
I'll second that motion. All in favor?
Aye.
Aye. That passes unanimously to deny item
Make sure and
number 7.
get with Paul.
That was my last question.
Yeah.
Was
Okay.
to be able to schedule that. Can I schedule that today?
Yeah, you
Just
should
an
be able to.
application, so it's just a matter of
Thank you.
Yep.
getting the application.
I'm glad we
started
were
the
able to
process.
find a solution for you. Okay, item number 8, approve or deny application for review by the Board of Equalization of the Farmland Assessment Act status for the Stewart property. serial number ending in 0017.
This one is an interesting one. I'm just going to start off. I often say that when I'm out in my garden and I have the bees flying around, that they're my little helpers on the agricultural side. I just wanted to state that before you started.
Okay. My name's Marianne Hansen. I represent Stuart Bagley. Unfortunately, he's not here today. He works for the DWR, and they got a big shipment of catfish from Louisiana. So he's out releasing catfish. But hopefully you don't have too many questions, but I have his family members here if you do. I provided you guys the information, and it's been a while since I've been down here. Do you want me to go over what I've already submitted, or have you reviewed it, or questions, or what's your preferred method?
Well, I have reviewed it. I find it interesting. And I guess my question is, and I want you to articulate this, because we're talking about basically the bees, and the use of bees as the source to justify its agricultural use, and yet the bees are going to be in California a lot, and back and forth in different areas here in the valley as well. And so if we had 1,000 head of cattle, it'd be really easy to see what's going on. But with the bees, they're really small. So I just wanted to kind of articulate all the way through. And I see all of the documentation of licensing for beekeepers. But how do we justify that the land itself is being used for the bees? Is it just the storage for the bees, or is it also for the use on an agricultural side with flowers and pollination or anything like that?
Well, I guess I'm sure that you read through the Farm Act, the Assessment Act that I provided.
I did.
They have provisions for beekeepers, and they always have to move hives around because they fight. So I've learned quite a bit in talking with Mr. Bagley. But one of you guys explain this. I'm not a beekeeper expert. Which one? Do you want to come up?
Come on up.
Okay, this is Dan Bagley. He can better explain that, but it's pretty complicated how they have to move bees around. So.
Yes. First place, you could not, we got anywhere from 8 to 200 colonies. And you cannot put them all in one place. And they can't be that way anyway because you have to relocate them all through the year. Like starting out in December, right? In December, you have to put them in location so that you can get them all together for one time, because you're going to load them on semis to go to California. And then when they get down there, you got to go down there with your forklift and unload them in a holding yard, it's called, down there. And you have to load so many in a certain area. If you're not careful and overdo it, the bees themselves, when they become active, will destroy each other. Each weak colony, the strong ones will kill off to take the honey, etc. Also, there could be a spread of disease that way. So that has to be taken care of the way it needs to be. And then when you come back, we come back and we unload them again in another location that lets semis get in and unload, because they're going to go into orchards. Well, we put them in California already and put them in the almonds. And they're in there for roughly 2 months. And what you get down there is maps from different orchards, and it changes from year to year, where you put so many colonies per location. And they have to be exact because they pay so much per colony for them. And then when they come out of there and everything's taken care of, and they need what they need, because that area down there, produces 80% of all the almonds consumed worldwide. And they get bees to go in there from as far away, if they have to, as Australia. And then when we come out of there, we bring them back here, semi-loads, place them in locations where the trucks can get in and out of, and with the forklift you can unload them, and then you got to hurry up within a few days and replace all of them in different orchards around here. And that's done in around, it's finished by sometime in April usually, depending on they let us know. And then we got to go in and pick them all up with our truck that holds 64 colonies at a time and place them in locations where they can produce honey. And that can be from anywhere from Hobble Creek Canyon to down to all around Utah County. And the places you place them will be where they produce the honey, but that changes according to, for example, is weather. The lack of water, you know what it does, and the plants don't produce. So then you got to pick them up and relocate them wherever you can find places to, and this is many places because you put around the largest amount you put in a location is about 50 colonies. So then you got to find places to relocate. Some you have to and some you don't. And that can be anywhere, even as up into the mountain areas if you need to, because that's got, you know, how the weather is and things. And this is taken care of until usually around the start of April, and then you got to bring them down when the alfalfa and stuff starts, because that's where one of the big producers of honey is alfalfa and different things. You bring them down, and you got to keep track of them because some you have to relocate immediately if nothing's going on or if they're spraying. Monsanto is a big cost of the loss of bees now because people, the bees will fly up to a mile away from their colonies. And so you got to keep an eye on things in case they start getting sprayed or whatever, or if they're starving or if there isn't any water or whatever. So you have to keep relocating, and it goes on until just about this time of the year. And then you got to go in and start bringing in the supers are called, the hives full of honey, and you got to run it through a process to get the honey extracted. And then you got to decide where you're going to relocate the bees, because they got to be sitting somewhere where they're not going to fight and carry on. And then you got to pick them up after that and put them back into a holding yard and have them ready for the semis to take them to California. So that's how many times you move the bees around. And you can't put too many in one location at all.
Right.
It had like 50 is about a max. If you get to, and you got to make sure you're putting them, because there could be other people around that only have maybe one colony and they're hobbyists, but the colony's got disease. And the bees will pick up the honey from that colony and spread it right through the whole, all of them. So you got to be right sure of what's going that way. So that's how many times you have to be moved.
So how would it affect your operation if you didn't have this? I think it's 6.2 acres. What would happen to your
Well,
operation?
that's one of the places we use. All the places we got are just about like that. And that's one of the places that Stuart bought. And that's the reason he bought it, because that was a pretty good location in Genola, as far as it's kind of on the hillside, and they can be put in there for sometimes just to produce the honey, sometimes just to locate them and get them ready to relocate and load them in the other holding yards.
So you have other holding yards too?
We have a holding yard is just one big yard that'll hold a semi-load.
Okay.
And you gotta be to where you can get to them without having to drive 30 miles one direction and stuff. So you have to make sure you can, and you have to make sure where you place them if they're, if it's good for them. And this area has been pretty good and something we're valuing.
How
yeah.
critical is this piece of property to your operation?
It'll affect big time because we're losing locations all the time now. And there's more spraying going on than there ever has been with Monsanto on that. And so you lose an area in it. Sometimes you can't even find another place to put them.
Okay.
And, and this is what you try to overcome, especially if you own the property. And so it's important. We need it. I'll put it that way. So.
Great.
Any other questions? I think there's specific provisions in the farmland, the FAA relating to honeybees, and I went through in the documents I provided to you that I think that the land clearly qualifies based upon the information that I gave you. This is a legit operation. This isn't just
We have to go
hobby.
there every year and describe and make out reports of how many we have and how much honey they produced. Each colony has to be reported on. So they keep track of everything, and we're all gathered with us as beekeepers licensed for Utah, and so the USDA is. They have programs going too, trying to help beekeepers, because there's big problems and there's a big need for them.
Okay.
Anything else?
Other questions? Diane, do you have?
Ben Stanley from the County Attorney's Office. So as the taxpayer pointed out, there is a standard of practice in the Farmland Assessment Act, Manual 7.5.1, that deals with apiaries and beekeeping in general. It lists some of the requirements that and some of the expectations and some of the avenues that evidence can be presented. The evidence that the assessor's office typically looks for is things like licensure, and they did provide a licensure document that their beekeeper is a licensed beekeeper, but also productions and sales and tying it to this specific property. So though it can possibly achieve a greenbelt status with beekeeping, there's a certain threshold of evidence and documentation that the assessor's office looks for, which is why this particular property was pulled off of greenbelt. It didn't reach that threshold with the reports that were provided, didn't tie the honey production to this particular parcel in the way that was expected in that office. And so if you have questions for Diane, she is here and can speak a little bit to what reports she's seen and what she's reviewed. But generally speaking, the law allows it, but it's not an easy threshold to meet. And the evidentiary requirement is documents that show how this particular parcel, as you were asking, Commissioner, has how this parcel contributes to that production specifically. And that's where the concern was from the assessor's office.
I'm trying to look up those docs now.
So first off, there is no doubt that beekeeping and honey production is an agricultural production, right? But to qualify a specific parcel, that production needs to occur on that parcel. That parcel needs to be the contributing factor for that. So some of the guidelines that the State Tax Commission has set out, because this has been something that we've been looking under a microscope for a while, because other counties had people qualifying and they just set vacant bee boxes out there. And so the State Tax Commission wanted to get some better guidelines so that the different assessor's office would have those. So one of the ones that they set forth was that the production needs to happen on that property. So sometimes people will put bees on a property and a parcel next door or, down the road a little bit are orchards. And those bees may pollinate those orchards, but they're not having production on the parcel where their beehives are sitting. They're pollinating another parcel. So that was one requirement, that it needed to pollinate something on that parcel. So what they basically set forth was that beekeeping in general is a supplemental activity on a piece of land. So they're growing pumpkins and they need the pollination for a better pumpkin crop. So they will have bees on that. Same thing for fruit trees and other crops and alfalfa. So usually the beekeeping or the bee production is like the frosting on the cake, and the cake is those other crops. So the other guideline they set was that parcels that were classified grazing 3 or grazing 4 that had really sparse forage would not qualify because there really wasn't much for the bees to produce. The bees are flying elsewhere off of this property to produce. So, so those are some of the guidelines that we've been given in my training from the State Tax Commission to look at beekeeping. I did contact them concerning this, and we went over it, and they confirmed, all the same things that are in the standards of practice. So on page 3 of the property owner's document submitted by their attorney, it has the breakdown of each month, where they are and what they're doing. So basically, the bees are not on the parcel for very long if they're on that. They might be in another holding yard, as they said they had other holding yards. So so those are the guidelines that are given to me for making these decisions. And also in the past, this parcel had grazing. They had livestock grazing on the property. And so that really is what qualified them, not the bees. And then now there's no livestock grazing, so that's kind of what triggered some of this.
So a question for you then. In a farming operation, a lot of times you'll have big pieces of land that don't necessarily produce anything on them because they're used for equipment, storage, whatever. They're used for holding pens, but they're still part of the essential process of the farming operation. And yet we still use them we still give them greenbelt status.
I don't. So the other guideline,
If a barn is being used to store
if that's
store
the
your
only,
hay,
but
if
if
your
that's
barn
the
is being
only,
used to store your hay because you raise livestock, we don't pull that out.
so he said if it's just that parcel and all that parcel is doing is holding equipment, then there's no production happening. Greenbelt is agricultural production. So there are parcels that are owned by the fruit growers, the Payson fruit growers, and the parcel is just the building where all the cherries come in and they're processed and they're done. That parcel is not on Greenbelt because that's part of the processing. Production isn't happening. But what Commissioner Gardner is thinking of is if you have 10 acres and you're growing hay and then you have a barn over here and everything, we don't carve out that piece and say, 0.38 doesn't qualify because there's a barn, because barns qualify when there's production on a piece. But if the piece is just an empty, vacant piece, which we actually had this scenario up in Lehigh, a vacant lot. It was next to the Lowe's up there, and the owners were saying that it was part of their operation because they are the emerald sod people, and they would cut the sod out in Cedar Valley, and they would transfer big trucks in that lot of these pallets of sod. It was their transfer station. It was just dirt, nothing else. And that went before the State Tax Commission, and it was denied because there's no production. So
if we
Greenbelt's
had-
production, not processing.
If we had 100 acres and they were grazing on this 100 acres and they had a lot of cattle on there and it was divided into 3 or 4, maybe 5 different parcels on there. And within one parcel was the holding pens. You would take the holding pens out of the greenbelt status?
If the holding pens were just used for loading the cattle to go into trucks, or if the holding pens actually had cattle in them for days or weeks or months, then if the cattle were there for a period of time, then it would qualify. But if it was just a transitional thing, like this sod farm where they just loaded the pallets and the trucks drove off, if they just gathered the cattle in the pens and loaded them in a truck and the truck drove off and the cattle were there for an hour, then that isn't production.
I see.
So what the law requires is a certain amount of animal units per month production from the parcel. And so if a parcel has production on 3/4 of it and storage and equipment on 1/4, then that AUM production from the 3/4 is often enough to satisfy the greenbelt status for the whole parcel. But if you've got multiple parcels, then you've got an issue. If they're all under one ownership and one parcel, then you don't have that same problem if you've got a significant portion of it dedicated to the storage and processing because you've got the production on the remainder, if that makes sense.
Yeah, but the whole point behind the Farmland Assessment Act is to help the farmer be able to operate without excessive taxation that can come. And I get it. I get it. The way we try to do it through standards and measurements is that we do it, hopefully through production, that's out there. But does anybody really think that if you have, you're saying it's the icing on the cake, so therefore the bees are just the icing on the cake. Then really what we're saying is that bee farming is not an agricultural.
No, it's an agricultural.
How do you measure that?
It just
'Cause you can't
usually,
measure that.
it usually
There's no tracking
isn't.
devices on bees that go from flower to flower.
Well, they
that would
can't
say it
fly
comes from
over
this.
and that's the whole point. If the parcel that they're on does not have the vegetative support for them, then that's what the State Tax Commission is saying. Grazing 3 and grazing 4 are very low-quality, sparse land, and so the bees are going to fly elsewhere, so there's no production happening on that property. If the bees are only there during the month of December, there's no production. And so that's kind of their guideline that they have given us for beekeeping, that it is more the supplementary, I'm a beekeeper, I'm a licensed beekeeper, I have beehives on my property, but it's not what qualifies me. All the other agriculture production, my livestock, my hay production, all of those qualify me. I don't
How many
qualify.
hives do you have on your property?
Currently 2.
Okay, how many hives do you have on your property?
300.
You say at least 50 because they have to have 50 on each place where they farm.
Right. So I think the qualifying, it doesn't qualify you because you only have 2 hives. They have 25 times what you have on a bad year. So what I'm saying is, what are the units for bees? What's the acreage per bee?
You know the AUM for bees, Diane?
I was told by the State Tax Commission a couple of days ago, 50 hives per acre.
If that's the case, it would
Hives
take.
per acre?
For a whole year?
And so they don't even understand beekeeping then.
Mr. Bagley has been doing beekeeping for 50-plus years, and he's indicating that you can't have more than 50 or they start territorial and they start fighting
Exactly.
and destroy each other.
I don't think they understand beekeeping, and I don't think they understand the value of bees to farming.
Right.
I think what the tax commission may be indicating is that it may not be practical or realistic, knowing the nature of bees, to have that many, but because of the production expectations, they want to see a larger number. So generally speaking, as Diane says, what the tax commission looks for is what is the primary support, the primary production, and then are bees a supplemental production. To make bees an exclusive production to qualify is not an easy thing.
I agree with that. I just, okay, let's just do an assumption that we get rid of all the bees and then we see what we do when it comes to farming activities.
That's what I'm looking at this. It's like,
They're essential. They're absolutely essential to the farming activities that we have going on.
It sounds to me like their bee ADU is based off of hobby farming bees, not commercial farming bees.
Right.
Right, because for example, they're saying, well, you can't qualify on bees unless the bees are pollinating an orchard. Well, then are you an orchard farmer or a bee farmer?
Right.
So just to clarify, when the State Tax Commission made all these requirements for beekeeping, they got beekeepers to put all their input. This took quite a bit of time. This has evolved over the last 10 years, and they actually deal with the Utah Beekeepers Association, and it was beekeepers who gave them all this information and told them what was the requirements and had their input. So commercial beekeepers from the Utah Beekeepers Association.
Well, I was a member of the Utah Beekeepers Association too, and I had 2 hives, but I was nowhere near a commercial beekeeper. But I was a member of the Utah Beekeepers Association.
Do you need any more information from me? Because I provided everything. I went through the standards.
I've been trying to open them, and mine, I have an error when I've been trying to open those standards. So I don't know if you have a paper copy for me.
Copies right here for you guys.
That would actually be really good, because I was just trying to refer to mine and I couldn't get them open.
Okay, I sent the entire thing,
Yeah, and
but I just have the applicable ones that.
Yeah, 7.5.1 is the most relevant on beekeeping.
thank you.
And in the 7.51, it says, in order to qualify for FAA assessment, land must be devoted to the raising of useful plants and animals with a reasonable expectation of profit. A few honeybee scenarios may qualify land for FAA assessment. For example, an apiary or bee yard used for staging or wintering. A large number of beehives may fully utilize the 5-acre minimum. And then it talks about parcels cannot qualify based on flyover of bees from neighboring parcels. Beehives must be located on the parcel in question. Then it spends a whole bunch of time about reasonable expectation of profit. My client, Stuart Bagley, we provided a copy of his beekeeper license. That's current. There's water. There needs to be an adequate supply of water. This property is located near a canal or pond. Forage, there is enough quality forage available in the hives throughout the season to produce excess honey. Quality forage blossoms include clover, cherries, apricots, dandelions, and various wildflowers favorable to honey production. And on this property, it's surrounded by alfalfa, cherry orchard, and wildflowers. And when the bees are on the Genola property, they actually go over. They travel at least 2 miles, so they are pollinating a neighboring orchard production. They meet with the USDA every single year, and they have to give detailed reports about production, cost, pollination, and moving beehives. The one other scenario is moving beehives. If hives are moved around the different parcels, adequate producers can easily be attributed to all parcels. And on this, they have to move them around.
Right,
You can't put more than 50.
at a time. How many do they own total?
Around 200.
Well, we've had as high as 800, and then we're down a little around 200 now.
They're dying off. And so it's been a real struggle. It used to be very profitable, but now with the cost of moving into California and all the extra costs, and they're dying off. And so we got to help the bee farmers, or there aren't going to be any. And so I think that just based upon the standards of practice, that this parcel in Genola clearly meets the criteria, enough criteria to be assessed under FAA.
Well, it literally says here, for example, an apiary or bee yard used for staging or wintering a large number of beehives may fully utilize the 5-acre minimum requirement.
Yes.
Am I missing something in that?
Well, no, I think that's right. I mean, the may is highly important there, but the sentences I would
So
point to.
literally just staging, like, I mean, we were just told that staging of cattle doesn't qualify, but this law says staging does qualify for an apiary.
Well, it says it may, and then it lists the kind of evidence you would look for to see if it does.
A license, which they have,
They do have the
water,
license.
which they have, or their bees would be dead.
The sentences I'd point your attention to,
Forward.
Commissioner, are, the very first says, beehives being placed on a parcel of land would not typically qualify land for FAA assessment. The
Okay.
other sentence I would point you to look at closely is actively devoted. The entire 5+ acres showing evidence of being actively devoted to the honeybee operation as defined in the statute.
Okay,
So those would be things I'd encourage you to look at, but
okay,
it's
so it's
ultimately your
six, what, it's
decision.
6 point what acres?
2.
6.2 acres. What percentage of that is not being used for the apiary?
There's a home on one little corner.
Well, there's a home, but they can only put 50 colonies in, and they don't take up a lot of land, but the other problem we have is you don't want 50 colonies in your neighborhood. And so,
But those colonies aren't there full time,
yeah.
right?
But they move them around, and the Utah farmers, they move them, it's locally, it helps Utah orchards. So they're put in orchards, they help the almond orchards in California, and
Do they have receipts from sale of honey?
they have tax returns.
Yeah, so we have receipts.
So I got a question for you on this. The moving beehives is an interesting one. Hives, if hives are moved around to different parcels, adequate production, and we're talking about production, can easily be attributed to all parcels. So you have all, I'm sure you have all the places that you place these hives and how their production, you know, in the almond orchards, up Hobble Creek, wherever they may be, which is kind of interesting. But anyway, that was I was the only one that got that. Wherever they're at, you probably have a documented list of where they've been.
Yeah, it changes, especially if you
Yeah,
go.
sure. But if it's
California.
documented and it's in the almond orchards, then it's showing that there's production out of the almond orchards, which
Yeah.
it says moving beehives.
Yeah.
And so, you know, why can't we appropriate that kind of production, you know,
Yeah.
to what's going on? Does it have to be owned by the company? I wouldn't think so, but
It's, okay, never mind, I lost my train of thought, I'm sorry.
So as I read the law, I read it saying, it literally says that an apiary or bee yard used for staging or wintering counts. So is our issue here that they don't meet the ADU,
production.
the production?
The production numbers are given to the USDA every single year, they're required to do that.
That's what they have to
So
know.
the USDA, they report to the USDA everywhere they've been, so, because they have to be able to track if there's disease and spreading among the bees. And so
Right.
detailed reports are given to the USDA every single year.
No, I understand that. So I'm trying to figure out why our assessor's office is thinking they don't qualify. An apiary obviously qualifies. They're not on production of honey. It qualifies just because it's an apiary. But my question is it that they don't have enough beehives per acre?
Well, 50 per acre is what she said. That'd be 6 times 50.
But it's $50, 50 per area, so they can't put 50 on one acre.
That's what I mean.
Yeah.
So it's unreasonable. It's not really.
Right, like, I'm just trying to figure out, so it's like literally the law, I just read the law. The law says an apiary qualifies.
Well, again, this
It
is,
doesn't compare it like a stockyard. It says an apiary qualifies.
well, again, this is the standard of practice, and it says an apiary may qualify. I don't want to speak for the assessor's office, but my sense is that they were looking at that first sentence, that putting beehives typically does not qualify a land.
Right,
For
throwing a
assessment.
couple of beehives on your 5 acres doesn't mean you
Work.
qualify. These guys haven't just thrown a couple of beehives on their 5 acres. They run an apiary,
Agreed.
okay?
And then I think they're looking for an active devotion across all 5 acres. And they've had these consultations with the tax commission who have told them that as a general rule, the honey production is seen as a supplement and not the primary source.
Right.
It's not generally what qualifies people.
except for an apiary. So I'm wondering, do we just not meet the production requirements for an apiary? The tax commission says throwing a couple of beehives on your land doesn't qualify you. We all agree with that. This is not throwing a couple of beehives on our land. This is an apiary. Under the standard of an apiary, why doesn't this qualify according to the assessor's office?
And again, my sense is that the understanding there is that the production is not tied to this parcel, so the flowers. aren't
Production
on the
doesn't have to
parcel.
be, it's an apiary. Why under an apiary doesn't it qualify?
We do a schedule and we get an average every year of how many pounds per colony of honey is produced per colony.
Okay?
It's right around 50 pounds per colony.
So 50 pounds per colony is what you produce, and you've got tax receipts that show that. So we have 50 pounds per colony times 50 colonies, 2,500 pounds of honey. Is that outside the scope of 5? Like what's the ADU necessary for that?
The AUM,
I mean, AUM,
Was
sorry.
fi-
I've been at the
50
housing, I've been at the housing meeting, so I'm saying ADU, sorry,
that's
AUM.
not how we typically calculate it. And again, that doesn't include a number that would be critical for the math, which would be how many total parcels are we talking about that we're dividing that production over, and how large are each of those parcels. Again, I think this decision from the assessor's office was predicated upon guidance they got from the tax commission about what's primary and what's secondary, and whether or not this should qualify. Diane?
So when you're talking about the honey production did not occur on this property. So,
Wait a minute,
Yeah, it does.
it does.
so they previously stated,
Going to the
they,
fields around there.
right,
They're
the neighboring fields that are not this parcel, the bees are flying to, and yes, it's beneficial. Yes, agricultural needs bees. All of those things, okay? But we have to look at the parcel and what the production is on that parcel. So during the month of December, when if they put those 50 hives, they're not out flying around in December. So they're not fighting with each other in December. They're inside their hives. They're keeping warm. They're keeping the queen warm. They huddle around the queen and they're keeping her warm. They box up those pallets to go to California, and they have nets over them and they keep the bees in. So during this
So they're wintering them there.
for 1 month, perhaps, they said.
Okay.
So there's no
They
production.
have to go through a period where they go through that.
Right.
But
So-
see,
So
right.
when you were talking honey, I'm just trying to clarify the honey thing. The honey is not produced on this because there's not forage for them to pollinate on this parcel because it is on a hillside, it's sparse vegetation, and they stated that the bees fly to other parcels.
Calling me at that time of
So-
the year. has
Ben,
an
could you come
average
tell me, is this an accurate, I mean, I want to make sure this is an accurate law.
got that.
Is this,
Standard practice.
that is the accurate standard of
I'm going to
practice?
state this on it. I get the parcel confusion, but it says if hives are moved around to different parcels, which they are, adequate production can easily be attributed to all parcels. So we don't have to say that it has to be just that parcel that produces everything. When it says here, all parcels can be used, because that's how.
Well, even beyond production, it says, an apiary used for staging or wintering a large number of beehives. I don't see a definition for large number. I personally think 50 is a large number. I've never had more than 3 on my farm. I had 5.5 acres. They've got 6.2. That's pretty close. The most I've ever had is 3. Right? They've got over 10 times that. Production aside, literally, for example, an apiary or bee yard used for staging or wintering a large number of beehives. It doesn't say it has to winter for 6 months. It doesn't say it has to winter for 5 months. It says wintering. If that includes 1 month, that's 1 month. When I was in Canada, wintering was 9 months of the year. In St. George, it might be 2 weeks. But if they're wintering the month of December on a property, large number is not defined in here. And that's why I've asked multiple times, did they give us a number of how many beehives had to winter per acre? If they have not defined that, then large number is up to our discretion. And it says may fully utilize 5 acre. They have 6.2. There's a home on it, but if it's 5 acres contiguous, which I don't see anyone arguing that, that's 5 acres. And then it says another scenario, not the same. It doesn't say and. When I say another scenario, to me that means or. Another scenario would be the intensive cultivation of special forage seeds intended to improve quality or quantity of honeybee production. But by itself, hence the, for example, an apiary or bee yard used for the staging or wintering of a large number of beehives may fully utilize a 5 acre minimum requirement.
And again, the way I would see that is if, the standards of practice, particularly this one, I don't think are wildly helpful for us. They
But
have
that's
contradictory
kind-
kinds of language. They say
that's
this,
kind of what I'm
this
getting at.
ordinarily doesn't qualify, this may qualify, large number, non-defined. There are issues with the standards of practice if you're going to base your judgment on that alone. Diane has talked with the tax commission, got some direction from them. We have tried to explain why the assessor's office made the decision they did. They're looking for an active devotion across all 5 acres. They're looking for a sufficient number that, in conjunction with other production and divided across all parcels, could justify giving this preferential tax treatment to this whole parcel. They didn't find that that was the case in this one. I agree that the standards of practice are not particularly helpful.
That's kind of
in
what
that
I'm struggling
guidance.
with, is I don't think the standards of practice are very well defined here, which would make sense. They're not going to devote a ton of our taxpayer dollars to creating standards of practice because there aren't a ton of apiaries, right?
Yeah.
So this is this is the only one that I know of in our county. So like devoting a ton of time for the standards doesn't necessarily make a good ROI for the taxpayers. But I'm looking at it, they have a beekeeper's license. They've got a source of water. There is some foraging around the area when they're not wintering. They have accessibility because there's a house on the property, so there's good roads year-round to it. No one has argued that there aren't at least 5 acres actively devoted to it. Production is the one that we wondered about, but if we're calling this an apiary that winters and distributes bees, we don't actually have to worry about production because that's not necessary under an apiary. Land
Although we
classification.
could take the neighboring winter, or, the moving of beehives and combine those for production.
Then we do have production, right? Okay, so we see production. Land class, it's fine. It's in an agricultural area. Moving beehives, if beeves are moved, they move them around, so we don't have to have full production on one place, to your point, Commissioner Lee. Forage cultivation is one. Says, 50% production requirement could be met by supporting 25 to 50 hives, so per acre. So that was only if they were going off of bee production, would they need forage cultivation? Going off of honey production. And then profit, obviously they profit. So I see one of the areas in which they may not qualify, which is forage cultivation. But I think they do qualify under a staging yard or wintering. So I see things that should be considered. I see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 potential qualifications. And I think they probably qualify on 8.5 of the 10.
And again, these aren't criteria or qualification categories. They're just examples of kinds of evidence that are helpful. But to your point, Commissioner, we don't disagree that there are commercial aspects of this business, that it's valuable for agriculture. My point is that I believe the assessor's office took it off of the Greenbelt roll because of this active devotion to the whole lot and the guidance they've received from the tax commission to look for flowers on the very parcel where they would be producing the pollen there, or producing the honey from the pollination activities on that parcel itself.
Right, and I think that was probably the correct direction to go if they were trying to qualify off of honey production. But I don't think they're trying to qualify off of honey production. I think they're trying to qualify off of being an apiary, which apiaries, I didn't see any production requirements in an apiary. that is used to stage or winter bees. Commissioner Lee, do you have thoughts? I'm interested in what your thoughts are.
So, I agree with what you're saying there. I would recommend that we continue this,
Okay.
not because of necessarily what we see on here, but maybe for some more exploration into scenarios.
Right, because we don't have, this is the only, we just don't have a lot of, I think, I was gonna say, the only thing is, as I read this, the two things that I'm not seeing qualified are large number is not qualified, actually. There's only one thing now that I look at it. For example, an apiary or bee yard used for staging or wintering a large number of beehives may fully utilize a 5-acre minimum requirement.
Right.
Period. They don't define large number.
Yeah.
So we don't know how many beehives they would have to be wintering there. And the amount of time that they're wintering is also not, that was the second one. That's the other thing that's not qualified. How long do they have to winter there? And how many beehives do they have to have? But I don't think we even have to look at production as an apiary. I think we're looking at, they're getting a profit off of the bees, but we don't know what a large number constitutes. And we don't know what.
And to your point,
staging is.
Commissioner Lee, I think one thing to keep in mind is you do not want to create a scenario where people can just dump a certain specific number of hives on their parcel to qualify for Greenbelt.
Right.
You
Right.
want to make sure that that is a legitimate, actively devoted kind of process.
But it's a legitimate business, but I
Right.
mean,
But there's no
moving,
dispute that this
moving
is,
hives
right.
all over is a legitimate business.
Right.
I think they've definitely met that through their tax receipts, through, other, I mean, we have a reasonable expectation of profit. They've got a license. They've got, I mean, I think we meet that, but you're right. You don't want to just be able to dump beehives on your property and
And
qualify.
I get it on the supplemental side if, you have a certain amount of AUMs that needs to be met and you maybe don't quite meet it with, let's say, the animals that you have, but then you go ahead and put a hive on there, it helps to supplement that into a point to where it becomes production, adequate.
And that's the scenario
and I
that
get
the tax
that.
commission, I think, anticipates.
Yeah, and
Right,
I,
and
and I
that
get
makes
that.
sense.
I totally
I
get
totally
that.
get that,
I
too.
think that's appropriate, and although it would be interesting to say how much of that honey actually came off of that piece of land versus their neighbors and everywhere else they're flying a mile to get there.
Right.
That would be really hard to. All we're doing is just assuming that they have forage and everything else. But if you're grazing, you may not even have any flowers. I mean, it could be
Right.
something totally different, but yet they still have a hive there. But I do think that if we continue this till the next, when's our next meeting? Is that the one that we just set? September 29th.
And my question, not to interrupt, is why are we continuing it? I agree wholeheartedly with Commissioner Gardner. I don't think there's anything else that needs to be presented.
Yeah.
Because then we're just going over what we've already gone over. The state tax commission, they're the ones that set these FAA standards of practice.
Yeah.
And they make exceptions for beekeeping. And I think it's pretty clear that my client qualifies. Like, this is a commercial operation.
Well, there's some questions I'd like to ask you, maybe, and some others, and maybe if we have some of these beekeepers that have presented this to the state, I wouldn't mind having some questions for them if we can have them come through. But I just think it would be wise for us. It's not that I disagree with what I'm hearing here, because I think you should feel that I'm on that same side of looking at this analysis, but there's probably just a little bit more that I'd like to explore.
And what is that? I guess I'm at a loss as to what else.
Well, if I had all the answers, I wouldn't need to, but I need to ask some
Because
questions still, I
come
think,
prepared.
for some more.
I presented my arguments and everything, and
Well, and you don't have to wait till the next meeting. If you have questions that you have, he can contact you and get the answers to those
Okay.
questions. So when he formulates his questions, he can ask you any of those questions in the meantime. It's just, we have to wait till the next meeting for the vote.
okay.
This is the first time this has ever come up
I guess
that I know
I'm-
of, for me
and
anyway.
I don't practice before you guys, so I'm not really sure on.
No, you're totally fine.
Yeah. So I'll make a motion that we continue. See, what item number is this one?
8.
We continue number 8 until our next meeting.
All right, I'll second that motion. All in favor?
Aye?
Aye. Okay, that passes unanimously to continue till the next meeting, and then just get with him to answer his questions.
Are you going to stay?
Yeah, that would be great.
Oh, at least we can start that process.
Okay.
I better just jump in here. I wrote a note on my paper here to remind the board not to contact the parties directly.
All right.
So just my advice is that you don't contact the parties ex parte, either the assessors or the property owners, as you're the
Well, if he has questions, how does he ask those questions?
Osmosis?
you ask them right here in front of, that way the assessor's office knows what you're saying to the property owner, vice versa, where, you're kind of an impartial judge in this hearing. And, it would not be appropriate to have one-on-one communication with the parties outside of the hearing.
I still disagree with that. You know I do.
Yeah.
One suggestion is that you could talk to other bodies if you wanted to talk to the tax commission about their standards of practice, or if you wanted to talk to
The Beekeepers Association?
Beekeepers Association, groups like that. Trying to think, Paul may have other ideas.
So you want me
but
to
there
get
may be some-
information, but I can't ask information from the appropriate bodies.
Well, from
That's-
the appropriate bodies, but not the parties.
Well, yeah.
Would be the most-
I thought he was
Again,
allowed to ask if I wasn't there, because then it's not a quorum.
Yeah,
no,
we're
it's not. It's
making
not
a
really
decision.
about open and public meetings. It's more about the decorum of a. In the Board of Equalization, again, you're wearing a BOE hat now as opposed to like a commissioner hat. In a lot of your commission matters, you can talk to whoever you'd like. But in the Board of Equalization, you're sitting more as an impartial judge, not as a legislative body. You're more as a judge, just judging the case here. And in that setting, it wouldn't be appropriate to talk with one of the parties separately. I suppose if both parties agreed to it and you wanted to have a conference call and you wanted to get both of them on the line, that might clear that up. Or you could talk to other impartial people who aren't interested in the outcome.
Okay. I'll take that under advisement.
He'll take your legal advice and do what he wants. All right, item number 9, approve or deny application for review by the Board of Equalization for the Farmland Assessment Act for the Buffalo serial number ending in 0014.
So the reason this was taken off was there was an ownership change and multiple applications had been sent out and no response. So I don't know anything about production because they didn't complete an application. So
Well, that's not true.
talking about production is not the reason why they were taken off, because I didn't receive an application that showed production.
Well, to clarify, there was no ownership change. New to this, never done it before. But that's not at all what happened.
Will you state your name for the record so we can
I'm
have a
John
minute?
Buffo. Sorry, I have a bad throat right now.
You're
but
fine, no worries.
I manage the family trust for my mother. She's sitting right there, so I brought her so she could be here. Nothing changed. What happened was there was a family trust, and in some of the wording in that trust, my dad had already passed away, so we couldn't fix it without going in front of a court and breaking the trust and redoing it, but he is no longer alive. She was the sole survivor of that trust, and all they did was re-record it back into her name, fixing the wording. And out of all the properties in that trust, this one parcel was pulled out. I don't know if it was you that I talked to on the phone. I only received one notice. We were told there was no certified mail. I got one mailing, and I responded to that in phone call right away because I didn't think it was right for us to lose our greenbelt status on that property. We run livestock on it. It is grazing. It's tied to our other farm property. So I'm unsure how, just by fixing a trust, it didn't change hands. There's no development. There's no improvements. There's no development. There's no power. There's no anything down into that area. So I'm unsure how we lose that.
So typically what happens is anytime the record our record changes, so anytime that there was a name change or a document change
Right.
on our recorder's records, then it triggers the questionnaire. So what would have happened is when the trust was fixing the issue and then correcting the documents with
Right.
our recorder's office, that would have triggered a review.
Right.
And then the assessor's office would have sent an application and somebody may have missed that application.
Everything comes to my PO box, so it wasn't that it went to a different mailing address. It didn't go to anybody else. I received nothing other than the one notice that I received with the assessment change and the cost. And I immediately that day called in, and this is where we're at right now.
Okay, so you're appealing that based on, you just didn't see that, but you do have production, you do have acreage.
Yeah, we run 22 pairs of cows on it, spring and fall. It has 4 horses on it year round. It has goats on it.
Okay. Have you filled out, so a new application will need to be filled out because of the change of, or the recording of a record with the recorder's office. Have you filled out that application?
Nobody's told me that. This is the first, anything I was just told that I needed to come to the hearing and dispute
Okay.
the loss of greenbelt status on it.
So
You've
here's
got
what,
2 years of
Yeah.
2 years of production that you can verify.
Yeah, nothing's ever changed on it. So, I mean,
Past production.
yeah, I mean, the property's been owned for 47 plus years. And
so,
we've ran cows and horses on it and goats and sheep and
so here's what I would say. This is my suggestion, Commissioner Lee. Well, you can jump in at any time. I would say we continue to the next meeting. You fill out the application, assuming the application comes back approved, then we approve this at the next meeting.
okay. I mean,
Does that work
that
for
would have
you?
been simple enough to do.
Yeah.
I'm gonna complicate it, sorry, board members. So it's 592509 of the Utah State Code that creates this rule that by operation of law, if a parcel changes its title or held ownership name, and it gives a 120-day deadline. And my understanding is that the 120-day deadline has passed. The good news is that my understanding is that the Board of Commissioners have been very favorable, especially when there hasn't been an actual change in who's working the land and who's physically there. It's just a
So
change in a
we could
name.
move this to that
It
meeting.
ends up getting, yeah, the cleanest way to do this, my understanding, and Paul can correct me if I'm wrong here, but my understanding is the cleanest way to do this is to say, yeah, the deadline has passed for the application to be prepared the traditional way, but the Board of Commissioners is generally very
Gotcha.
favorable
Okay.
to adjusting that under the green folder process.
Not a problem. So it's just a little bit different. So this is what you'll do. We'll go through today, and because you're over the deadline, correct me if I'm wrong.
But can I ask a
Yeah.
question though? If that's stated as like a law, I guess, shouldn't that have been certified mail so you guys know we received it? Because you can't say that I received it if there's no record of it.
Well,
Doesn't say, yeah, it doesn't say.
Well, I'm just saying that that's unfair
For the
if
future,
it doesn't
right.
come to me because the mailman dropped it or
I'm sorry.
it went in
So it
another
has
box.
nothing to do with whether he received the application or not. It has to do with whether he completed one. So it falls on the owner's responsibility to complete an application when something changes.
Gotcha.
We send them out as a courtesy because that helps people. But a lot of people come right into my office after they change the ownership so they can be on top of it, which we then have to wait
But
until
nothing
it
had
actually
changed in
changes.
ownership
But
is
you
what I'm
didn't-
saying. And we
right.
sat in court and even our attorney and the state, when they broke the trust, clarified that there was no change in ownership of that. So
Yeah.
it was just, my dad was dead, so it was removing him off of that at the time. And so instead of the Guido and Joanne
Mm-hmm.
Family Trust, it became the Zola Joanne Trust.
so
Nothing changed in ownership. And I'm saying, so as us as not knowing, you can't tell me I had 120 days because we didn't change ownership. And us as the landowners didn't know that that law even existed. And you can't tell me that you sent it to me because I did not receive any notices. And if you're the lady that I talked to, I literally called you that day and we started the process that led me to here. And nobody even told me I needed a new application. Otherwise, I would have started that process. But literally for 40 plus years, almost 50 years, that property has been the same. No improvements. There's nothing the state has done to improve that area in the ground. We maintain the road, we maintain everything. So it's unfair to us to then just get told, well, by the way, we're going back to 2017, pay your taxes current, and tell me that I only had 120 days, that you can't prove that you even notified me of that.
Have we, this is a question of the county.
And nothing changed in the ownership.
Have we ever continued the greenbelt status after 120 days?
All the time, because people don't respond.
But how do you
We
respond?
give
I
them-
understand
we
if
give
we
them
sold the
lots of
property
grace
or,
period.
or I bought it from my parents that it was changing, but nothing changed. When we sat in court, that was a question when we were retitling it. And the judge, the attorneys, everybody said,
Law says 120 days, and yet we keep greenbelt status in place after 120 days.
And we send them another one and sometimes 3 or 4 just to try to,
which I would have responded to that, and hence why I'm here. I'm saying we never received that, and I didn't know there was 120 days in court.
So how
They
do we-
literally told us that there was nothing that was going to affect our greenbelt status.
No, they wouldn't.
The judge, everybody agreed that all we were doing
Hold
was
on one
fixing it.
second. So why don't we just send them another application and get it done if it's passed?
I sent you the copy of the Greenbelt notes and how many applications I've sent out. So do I send out 20? Do I send out 3? Do I send
Well, here's
out
my question. If
40
it's going to
over 8
affect
years? How many do
somebody
I
that
need to
didn't
send
change
out?
ownership,
Well, in this case, I don't know about others, but
Well, I'm
in
saying
this
in others,
case,
I understand
hold on,
you would
hold on.
notify
Hold on. So in this case, what if we were to strike this agenda item and you'd send another application, and if it gets filled out, then we can proceed and go forward. But if it doesn't get filled out, then you're probably going to run into a problem with the commissioners on it.
correct. I'm just saying,
that,
I'm only
Paul?
answering what I know, and I mean, literally,
No, we get it. We're trying to figure out legally what we can do. We'll make it right for you. We're just trying to
Yeah.
make it as easy as possible.
I just mean with the assessor's office, like even before this meeting, in my communications, I only got a voicemail, I think it was on Friday, saying, oh, by the way, tell us how many animals you have on it and submit us your tax records. And literally that's 4 days before this hearing. And how do I answer that? Do you know what I mean? Like, I'm just saying 120 days is 120 days if it exchanged hands. And our attorney addressed that with everybody in that over this property of breaking the trust.
Okay, Paul,
And,
can we
and
do
that's
that?
where I'm just confused on that.
Well, Diane's right. The law says after 120 days of changing ownership, you need to file an application. There's no notice requirement. It's a responsibility of the property owners to do that.
Which I would agree.
So on the one hand, I suppose you could look in. I mean, I don't know where the board is on whether or not there was a name change. I mean, sounds like there was one trust, and then, well, sounds like Mr. Buffo is saying that there wasn't a name change, but
They just took one name off,
Because he was deceased.
right?
so there's
Right.
that issue. Now, if you struck this, and I mean, one of the differences, and I know that Ms. Garcia just said that, yeah, sometimes we do accept applications after the 120 days.
Wait, how do we do that if it's the law for 120?
Right.
But if sometimes we do, then
And I mean, that's the point. If it's subjective to the
Well-
law and not the law, then how do?
But of
so
course-
can we pull that into here and give us some subjectivity to it and say, let's just strike this off and send another application?
Of course, that's before the rollback is initiated. And so at this point, the property's been withdrawn and the rollback is triggered. And
we still
so-
have to abate it.
And so it's a different scenario here entirely because in
Because
the other
of the
scenario, there's
rollback.
no rollback.
Because
In
the
this
rollback
scenario-
is
or
not
it's never been
question
withdrawn.
Though,
but-
is if we didn't receive the notice.
Yeah,
I
the
mean,
notice
you
thing.
guys have my email, you guys have.
Yeah, the
And if I
notice.
received nothing that states that this is happening, and we didn't change hands, like I said, literally, when this
Yeah.
was being dealt with, the attorneys addressed all of this, because this is all new to me. Literally, it was all asked about that because of the properties being in the green belt.
Yeah.
Everybody agreed that there was no title change, there was no nothing. If my dad was still alive, we had to fix some verbiage in their trust.
Right.
And in doing that, my dad was deceased, so he could no longer, and all they did was remove his name. And it hasn't affected any of our other properties but this property. And that's what I'm saying, of like, you can't prove to me that you sent it because the mailman dropped it, or it's in my P.O. box, and I get mail for strawberry water, they were talking about. I get it for a bunch of construction people that used to own my P.O. box before. What makes it any different if that notice went into somebody else's box and you turn around and you put it in this isn't to me, and it never goes back because it goes back to somebody else or it goes to the debt.
How many days has it been?
I don't know because
When
I
did you
mean,
do the trust? When was that?
We did the trust. How many, I mean, two,
Document was recorded February 26th from what I'm looking at, 2019.
so,
2019.
so back then, like I said, and we had no knowledge of this even taking place until I received the notice saying this is taking place, blah, 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 called it. And literally when I called and I said it's about Greenbelt, I got told I can't even talk to you, just send this email, fill out this, blah, blah, blah. And then like I said, and then we're into the 4 days of before we're,
When did you receive that
the first
the
notice.
one communication that you're talking about?
The very first notice, I think, was back in, we're in August? Probably about May, I think it was when I called, and then we said, because you guys didn't hold the one meeting, so I had to wait till the September meeting to get here. And then the last thing I heard was, I got sent over an application, filled it out, sent it over.
What was the
and then-
notice that you received?
It was just
That
telling
you-
me that
that
we
you need
had
to
lost
fill
our
out-
Greenbelt status.
Oh, that you
and
lost the
the
Greenbelt
rollback had
status.
taken place, and it was going back to like 2018, 2019 or something like that. And the taxes were due by July. And if I had any questions to call the county assessor, which I called, and then this is where I'm at.
Have you sent out? I mean, sometimes you'll send out notifications. At least I thought you did anyway. For if they're
Application,
yeah, for applications.
Yeah,
But we didn't even know we had to do an application because
I provided the Greenbelt summary in my documents to show you how many times I've sent out applications.
Bert's telling me over here that since 2019, at least 3 notices went out.
Yeah, so that's kind of problematic for me. I get it where you're going with it, but if
Do we know what
if
address they're
we're-
going to?
If you received notifications 3
The
times,
PO box?
you don't respond.
the PO Box 207.
I was just looking at the property history record in Diane's, in the assessor's documents. She shows that an application was sent on August 20th, 2020, on October 11th, 2021, and on May 6th of 2022. The address of record that they would have been sent to is the PO Box, PO Box 207, Springville, Utah 84663. I also checked the valuation and property tax notice. Up until 2017, the tax notices and property valuation notices were coming back marked as undeliverable. But after that, that was when the address was changed to the PO Box, and we've not had anything returned to us from the post office since then. So my assumption is that the PO Box address is correct and that any notice sent there would be going to that PO Box.
And there's never been a late fee on the taxes everything I receive has been addressed with.
So here's how I'm seeing it. 2019 is when the change happened.
Right.
And I don't remember all the dates on here, but it looks like there was notification sent to file an application even past the 120 days 3 times and with no response. But then a file or a notification went out finally saying we're gonna roll you back on that, and that one got your attention for some reason because now you're getting rolled back on it. So how do I justify that?
I can't tell you because honestly, I'm the only one that has access to that PO Box. Been taking care of everything, like I said, whether the tax notices and everything. I have never received a notice about that. And going back to like undeliverable, my parents sold their house around that time. The tax notices and stuff we updated to the PO Box, and they were still being sent to their old address, which at the time we knew the people that owned the house, and we were receiving that through that way. So I can't answer that, but
Sir, I would, and I think this group knows, I would fight like crazy for Greenbelt stuff on a regular basis. But I'm really having a hard time with this one when it looks like it's been sent out there multiple times over the years, and there's been no response to it. I don't even know, what is the rollback on this? How much is it?
Hang on.
I'm trying to get to the
I'm looking at
application,
it.
but
they rolled it back
Looks
to
like-
$478, so they want like it's an $1,800 and something bill that's
Yeah.
due
It looks
now,
like 1,200 maybe.
Was it
I don't
$1,200?
know, Commissioner. I'm struggling on this one just because
Well, if you let me interrupt here. Even with, so I mean, I think establish the notice issue, but I still think the notice issue is a red herring for all
I
of
agree.
us. So even for you, for the board,
Yeah,
the notice issue
I
is
think the
not
notice
really
issue is a red herring. I think the
critical
issue here is,
here.
are you farming on the land? Does
Well-
the land qualify for farming? I think
Yeah.
it does.
I think that's one issue. I think to go in order, was there a name change? Okay, if the answer is yes, then did you file within 120 days? And the answer is no. Then I think it falls back into that resolution from 2018. We have a technical name change without a substantial change in the operations, and it goes to a green folder situation. But that's my take,
Right.
if that makes sense.
Which means that so my take on that is under the law. I agree. I think this is a technicality. Whereas technically it didn't change hands. One person just became deceased. Right. So there's like a crazy technicality, which we can't handle in BOE, but we can handle in commission meeting. Right. So then I would say that the process is we deny in BOE because this followed the correct path, but then he fills out an abatement application for the commission meeting and then fills out the correct application to get back on Greenbelt. And then when the abatement comes before us as commissioners, traditionally, if your Greenbelt status has been restored, we abate the rollback.
Defer and then abate, but yeah.
Defer, yes,
And then stay
abate.
on for 5 years.
Right.
Yeah, and
So I
that's,
think we absolutely have a process to handle this, that all of the rollback will be abated.
Well,
But I
well,
think we have to follow the
well,
process.
possibly. And my whole point behind this is that I see no way that, I mean, you call it a red herring, but it is part of the conversation. And there's no way that we could approve of this application as it's stated in number
That's why
9.
I'm saying that part of this process would be to deny this
Yeah.
and then have him apply and get back on Greenbelt and then abate the rollback and fees. And then in commission meeting, we would then defer and abate after 5 years.
Yeah, and I
Correct.
guess one of the reasons I called it a red herring is because he has the responsibility to apply whether he gets notice or not.
Right, right.
Right.
Notice is not even required.
Totally understand that. I mean, it's a service out there, but it does say, I mean, it's been going on since 2019. I mean, we're focused on this 120 days, and yet we're years, and notices have been sent out, which the assessor's office doesn't even have to send out.
But again, I'm saying I didn't even know, nothing changed hands. I mean, literally, if that was the case, then that would affect all of our other properties, is what I'm saying. And when this was addressed in the court, it was not to affect any of our Greenbelt status. And if my dad was still alive, we wouldn't even be here because
That's right. We wouldn't.
and that's what I'm saying. It wasn't, we weren't doing anything with the property. It literally was the wording in their trust that affected why we had to do what we did. But it was after the fact of my dad dying. And as for the notices, maybe I saw it and I didn't say it, but I'm just telling you, I promise you, I've never seen anything that I understood was an application or something that I needed to resubmit on the property. But the notices that I've got, taxes, the notice on this, I've responded to everything that I understood that I needed to respond to.
I don't know about your other properties, but your other properties probably have, if they're in this county and in other counties, have the same problem.
So, and I'll call the attorney and talk to him, because like I said, literally, that was our biggest concern over redoing the trust. Because if it was gonna affect our Greenbelt status on the properties, we wouldn't have broke the trust just to fix some wording.
Yeah, and if nothing's happened on the other properties, then I would get in as soon as possible and make sure and put an application in. It's the easiest way to just kind of get past the whole thing.
And then go through the
Yep.
deferment and abatement process.
Sorry, the phone call dropped off of Zoom, so which means our recording has. We haven't been recording for like the last 30 seconds. It just
Oh, that's
barely
okay.
dropped.
30 seconds isn't that?
No, it's not.
Should we wait then?
Yeah, let's reestablish the phone call.
But it's on Zoom. The Zoom window is open.
Zoom's not recording.
Recording.
Adam Beck can't hear us.
But you can.
Adam Beck can recite the last 30 seconds. He's got a memory like that.
You don't want to know if I do. But yes, I actually probably could. My poor husband. Yes, I could probably word for word recite it back to you.
Go for it. Then Sally, just record.
Welcome to Zoom. Enter your meeting ID,
All right.
followed by...
All right, I'll make a motion. Oh, sorry, I thought.
Should we recap the last 30 seconds first?
Yeah.
We'll put Commissioner Power Gardner's,
Enter your participant ID, followed by pound. Otherwise, just press
Right.
pound to continue. You have joined the meeting as an attendee and will be muted throughout the meeting.
All right. The recap was
The host would like you to unmute your microphone. You can press *6 to unmute. You are unmuted.
All right. Commissioner Lee stated that you should probably check with your attorney to make sure that the other counties didn't have this process. In the meantime, get your application filled out and get it right, in which I mentioned that we should then defer and then abate in a commission meeting. And then we were ready for a motion, but before which Mr. Zola,
That would be my mother.
Mr. Buffo.
Yep.
Mr. Buffo mentioned that he was going to get with his attorney to make sure that the other ones were not falling off of Greenbelt, and also mentioned that they would not have gone through changing a few words on the trust if they had known this would have caused issues with the Greenbelt. All right, now I think we're ready for an emotion.
I'll make a motion that we deny the application as stated in number 9 on our agenda.
I will second that motion. All in favor?
Aye.
So then the next step is the defer and abatement application.
Okay,
So
Call.
well, the next step is a Greenbelt.
Greenbelt, yeah, get the so fill out your Greenbelt application,
So where do I get that?
Diane. And then after you've got that application, then you'll go for a deferment and abatement in a commission meeting for the
And do
rollback.
I schedule that with her or?
You can do it right after this meeting.
Yep. Yeah. Okay.
Okay, that's, okay.
All right.
All right. Are there any, I guess we don't have public comment on the agenda. I don't see that on there, which means that we're ready for a final motion.
Motion to adjourn.
I'll second that motion. We are adjourned.
Good